Hello, everyone. My name is Montserrat Madariaga. I am a lawyer at Legal Response International, and I'll be talking to you today about the law and governance of the UNFCCC regime or the climate negotiations. So today's session should be kept under an hour, and we're going to cover four main topics. First, an introduction about the role of the law in the negotiations, followed by an examination of the governance of the regime, of the different bodies that compose this regime and this architecture, and then moving to practical legal aspects, sort of the rules of procedure that regulate how we negotiate, and then finally an examination of certain elements of importance for text analysis and text drafting, like the legal terminology and the different parts of a treaty. This session is aimed to provide you with tools to understand better this regime, and also if you're a negotiator or an NGO aiming to have an impact in the negotiations, to be able to further enhance your possibilities to have a meaningful contribution to the process. So first, the law in the negotiations. So why is the law important in this regime? Well, first, it's what you are doing if you're negotiating, or what's happening there if you're observing, is that parties are negotiating legal text and they're using legal language, because all of these treaties and COP decisions are ultimately legal instruments. The law also regulates the governance of the regime, so the different bodies that are there were established by a treaty or a COP decision. Their functions were determined in a legal text, so of course it's very relevant to the governance as well. Then, as I mentioned before, the law regulates how we conduct the negotiation, and this is particularly drawn upon on the rules of procedure, but also in other agreements that that tell us how we should negotiate. For example, the principle of good faith, which is an international law principle of customary international law. And then finally, the law can support your political arguments. So it's really a useful tool to have when you approach the negotiations, because many times you need to anchor your idea in a mandate or in a function of a relevant body. And in order to do that adequately and within the functions of the deciding body, then the law and the knowledge of the law can really support this argument that you want to promote. Some questions for reflection that maybe illustrate what I was just saying, or why the law is so central to the process. So a first question is, does it make a difference if a text, either a treaty provision or a COP decision, says shall instead or should? Do these words carry a different weight, a different meaning? Will they translate in different obligations? A second question is, are COP decisions legally binding? Do they have normative power? Since we spend so many hours debating about every little word in these COP decisions, it's important to know what's their legal value, right? And then, can the Paris Agreement Implementation and Compliance Committee, the PIC, can it sanction countries if they don't present their NDCs or their nationally determined contribution, that it has sanctioning powers? Can it fine countries or any other form of sanction? And then finally, of course, can you imagine a world without lawyers? Not in the negotiations, I would say. So a bit of context here. So we start on the law. The climate law is basically, but not exclusively, the climate treaties. These are the main instruments that that contain the international climate law, right? These are the climate treaties are three. The UNFCCC Convention, which is a framework convention where this regime is established, where the COP is established, and with an objective to keep emissions to a manageable amount and to prevent dangerous interference with the climate system. So it sets sort of the field, the structure, and these commitments. Then we have the Kyoto Protocol, which basically sets emission limits to developed countries, and this is why we say it has a top-down architecture where it tells countries how much they can emit. And then finally, on 2015, a new regime was agreed, or a new treaty, and this is the Paris Agreement, which has a bottom-up architecture as it's been defined, because countries are supposed to all contribute to the objective of the convention and the Paris Agreement through a nationally determined contribution. So the aggregation of these contributions that are determined at the national level will implement the common objective of the Paris Agreement. A couple of clarifications. All of these, regardless of their names, are treaties, convention, protocol, agreement. They are treaties under international law, and therefore they are governed by the law of treaties, and they're binding for the parties who ratify them. They all have different membership, but it's in any case very high, almost global for the three instruments. As I said, this is the sort of bulk of international climate law, but it's not the only source of international climate law. Very recently, we heard from the International Court of Justice and other international courts on their advisory opinions about climate law, and they emphasize that other treaties of environmental law as well, human rights law as well as customary law, are relevant sources for climate to determine the climate obligations that states have, and they suggest a holistic understanding of climate law, not a silo understanding of climate law. The sort of obligations that we find in international climate law and in the treaties are obligations of procedure and obligations of result. So some of them entails doing something, sort of presenting certain information, the biennial reports, for example, and others entail substantive obligation of result. And so, for example, the collective obligation to keep to 1.5 degrees would be an obligation of result, right? Interestingly, we used to think, or some people used to think, that the obligation to present an NDC was procedural because the obligation was only to formulate it, but actually the advisory opinions have confirmed what others have been arguing for quite some time, that is also an obligation of result, in the sense that they need to be adequate to achieve the objective of the Paris Agreement. And so in that sense, they're also an obligation of result. Not everything in the treaty will be a legally binding obligation. We also find non-binding commitments. For example, in Article 9.2 of the Paris Agreement, there's this voluntary commitment call for all parties, not just developed countries, to support with climate finance to more vulnerable countries. And so we find a mix of binding obligations and non-binding commitments in these agreements and in the COP decision. The position where the provision is also makes a difference. So the preamble of a treaty or the preamble of a COP decision will have interpretative character, so it will allow to interpret the obligations of the treaty further. And then the relationship between COP decisions and climate treaties in terms of their interpretative power is that they further, of course, COP decisions further implement the treaties, but also they help to interpret the provisions of the treaties and can, in some cases, constitute subsequent agreements. So when we hear from the COPs over and over that the commitment is actually the temperature goal is 1.5 and not 2 degrees anymore, because we need to recognize the state of affairs and the best available science, then this 1.5 would have sort of replaced the 2 degrees in the original treaty through the recurrent interpretation that parties are making COP decision. And this is something that was also confirmed in the recent advisory opinions. So this is basically the law, or some aspects of the law. And now we're moving to governance, to examine the governance of the regime. So there are various bodies in this in this regime, in the UNFCCC. So we have the governing bodies, the subsidiary bodies, the constituted bodies, and then we have the secretariat, and we have the COP president, and we have some other, then we have observers, we have some other actors there. And so all of them together would constitute the governance of the regime. So it's really important to determine who has power to do that, how they relate to each other, what should be done by the COP, what is more for the SPs, what is for a constituted body, who mandates the constituted body, etc., etc. And so we'll examine briefly all of these bodies and relationship among each other. So first, the COP, the CMP, and the CMA. These are the 3 governing bodies of the 3 respective treaties. Basically, the Article 7 of the UNFCCC Convention established the COP, and then similar provisions in the Kyoto Protocol established the Conference of Members to the Protocol, the CMP, and in the Paris Agreement, the Conference of Members for the Agreement. But their functions are similar, and the way they operate is similar. They actually operate in the same space, in the space of the COP, but in the same COP, as you already know, sometimes the meeting will be exclusively to discuss some agenda item under the Kyoto Protocol, and then it would be the Conference of Members of the Protocol meeting in that space and agreeing on a CMP decision, and the same happens with the CMA. Basically, the COP, the CMP, and the CMA, as supreme bodies of these treaties, they have to keep under regular review the implementation of the respective treaty. And as I said, the COP serves as CMP and CMA with the respective membership because it's not 100% equal. In order to implement the treaties, the COP has, and the CMA and the CMP, they have functions, different functions that are set in the treaties and that are expressed through COP decision. This is why the COP reaches decisions, so many decisions, and this is the ultimate product of a COP. So the first, there's many, but the first that I wanted to highlight is that the COP should periodically examine the obligations of the parties and the institutional arrangements under the convention. And this is why there are so many COP decisions setting up new bodies, new mandates, work programs, etc., as a consequence of these periodic reviews and implementations of the convention. They should make recommendations on any method necessary for the implementation of the convention. The COP should also seek to mobilize finance. Then an interesting one is that the COP should agree and adopt on rules of procedure, something that still, and we'll see that later, still hasn't managed to do. And then there are many others. These are just a couple of examples to give you an idea. And then the final sort of provision says that they should exercise any other function that is required to achieve the objective of the convention, or and equally the protocol or the Paris Agreement. And so, for example, creating constituted bodies to advance on the work is one of these functions. Then the COP, as we know, they meet once a year, and so it wouldn't be too efficient to have that single meeting, and this is why there are other bodies that work throughout the year to advance on the negotiations. And one of these bodies are the subsidiary bodies, which are permanent bodies. And as you can see in the slide, they were established in the treaties, not like other constituted bodies that are established in COP decision and that might be temporary. These are permanent. And so one is the subsidiary body for scientific and technological advice, and the other one is the subsidiary body for implementation. They meet twice per year, once in Bonn and one during the COP as well, in Bonn usually in June. And basically, this is like, in reality, it's more like a mini COP because it's a negotiation space, but where parties are allowed to have a more technical discussion, more detail, and come to COP prepare with this input from the negotiations in the SBs. And so what are these inputs? As we see here, these are conclusions. So the SBs come to conclusions, not decisions, because they're not the governing body. But they also work on draft decisions. So the negotiators that will be working in agenda items that are similar to the ones that then will be worked at COPs and CMAs, they seek to use this time to advance in draft decisions. But of course, still the COP, the CMP, and the CMA, they keep their status of governing bodies. So in this sense, they are sort of mandating the SBs or the SBs as an agent of the COP to advance in these negotiations, but the SBs cannot keep to themselves any function. They're not exclusive. They cannot retain any sort of decision from the COP because they only exist, as the previous slide was mentioning, they exist to support the COP in their endeavors and in reaching these decisions. Here we have a picture of the Bonn conference center. This is a plenary session and in the negotiations in June. In addition to this, the COP as governing bodies and the SBs as the mini COPs supporting the technical work of the COP, we have the secretariat, we have the president, as I said before, and we also have constituted bodies. So the secretariat was also established as part of the convention. This is why we have the provision there. And the role is to assist parties, to prepare reports of their activities, compile information and other reports, make the arrangements, logistical arrangements for the COPs and the SBs, and then any other function that is determined by the COP. And we see how many COP decisions include a mandate or a request to the secretariat to host a dialogue, to produce a report, etc. And so the secretariat very much responds to the parties and the indication and the requests that the parties make. but it is also subject to financial constraints. So in the COP decisions, we also find that line saying that yeah, they're requesting something to the Secretariat, but mindful of the financial constraints that the Secretariat might have to cope with all of these functions and requests that the COP and the governing bodies are asking of them. The Secretariat has an important role assisting the negotiations, the co-facilitators. We often see Secretariat people in the room sitting by the co-facilitator, or here in this picture, the Secretary of the UNFCCC with the COP29 president. But we should remember that this role is of assistance and that this is pretty much a party-driven process. And so this is a supporting role, more like and it's not a driving role that the Secretariat has. Moving to another character of the COP is the COP president. And so we have a picture here of the incoming president for COP 30 with Antonio Guterres. And so the COP president basically is chairing the COP and the CMA and the CMP. Is a big chair of these meetings. And according to the rules of procedure that we apply in draft form, the presidencies rotate among themselves, and they rotate they take turns in the 5 regions of the world. And so every 5 years it would come back to the regional group to decide, to suggest, to promote a single candidate to host the next COP. And so 5 years ago, it was the turn of Chile, Latin America, and now again, Latin America. The role of the co-president is to control and lead the process, to conduct the process, to decide which sort of meetings, where, when these are going to happen, but always under authority of the COP, CMA, and CMP. They also have a role of political leadership. So we've seen, for example, the presidential letters that come throughout the year to start preparing for priorities at COP30. They also host presidency consultation on topics that might be perhaps outside of the agenda or difficult topics in the agenda that need an extra push from the presidency. They also draft text. They offer presidency drafts. So, for example, the new collective quantified goal decision last year came from a presidency draft that was presented directly at the plenary, because in the negotiation room, it wasn't possible to reach a final draft, right, to be forwarded to the plenary. The co-president has a duty of impartiality, which in reality, of course, is a bit tested, because there's also the practical aspect of hosting a COP, which gives you a lot of visibility. And so every COP president wants to lead a successful COP. And so many times we see that maybe, there's compromise on reaching a decision, even if this decision is not satisfactory to most parties, just because of reputation. And we also see that sometimes COP presidents are pursuing, of course, their own interest or their country interest. So the duty of impartiality is tested in reality, and is something that that we should keep, an eye on. And in terms of more sort of formal duties, the rules of procedure say very little. They, of course, do not say anything about, the logistics of the COP or the duty to ensure affordable accommodation for everyone. That's not there. It's very little what we can find in the rules of procedure, and they're more formal. So basically, to declare, to conduct, to assist in conducting the negotiations, in the sense of declaring when the quorum is there, also declaring when a decision has been reached by consensus, because consensus doesn't mean the same as unanimity. So it's the COP president who will be sort of looking, hearing, and if he finds that there is no significant objection, then he declares the decision as adopted by consensus. So that's quite a strong power, formal power. They also give, they rule on point of order, if there is a point of order. They organize the different negotiation settings, like this is going to go on informal consultation, this is going to the plenary, etc. So, of course, these are the formal duties, but in reality, as I was saying, COP presidencies have other expectations and other roles. The COPs are becoming very large, so a COP president should be ready to also face a tremendous challenge in terms of logistics and funds, financial budget to be able to host a COP, because it costs a lot of money, of course, for the hosting country. The exercise of power can be described as discretional, highly discretional. As I was saying, for example, when they declare consensus, like, well, but what if, like, they decide what objection is viable and which is non-viable, right? So this gives them a lot of discretion. The possibility to say, oh, this is going to go to informal consultation, it's not going to be in transparent negotiations. That's also quite a highly discretional exercise of power. They are under a lot of pressure to deliver an outcome. And so many times they also tend to push for maybe more flashy cover decisions, to send these big messages, to show, to evidence success that in the COP that they presided. And as I was saying before, they should be neutral, but international reputation and domestic interest can have an impact on how they behave. And so because of all of these, some have suggested ending rotating presidencies, maybe centralizing the COPs in Bonn or in Geneva, or they also, some other ideas are that the COP can only take place in climate ambitious countries. Ideas that are floating in research or in campaigners or even in the negotiation room, and that should also be should be examined, and to ensure that, of course, negotiations remain inclusive, equitable, and just. Now, I'm coming to the end of sort of the different bodies. We went through the COP and the CMA, the SBs. Then we talked about the Secretariat and the President who assist the COP and the CMA. And I want to now talk a little bit about the constituted bodies. So what are these constituted bodies? The constituted bodies are specialized bodies with limited but representative membership, established either by the treaties themselves or by following COP decisions to further implement the convention. And so we have, for example, the Adaptation Committee, the CTCN, and we see a picture there of the advisory board in a recent meeting. We have the PIKE, the Paris Agreement Implementation and Compliance Committee, the Standing Committee of Finance, the WIM, which is the Warsaw International Mechanism for Loss and Damage, and many, many others. Because they are created by the COP or the treaties, they, in order to assist the COP in their functions, because some issues need to be, of course, discussed and advanced in a smaller, more technical groups, they report back to the COP, because again, the COP is the governing body. They often have their own governing instruments where issues like the membership, the way to make decisions, the role of observers in these constituted bodies would be established. So this is when we hear about all of these bodies, this is the category, constituted body. This is the role to assist the COP, and they always have to report back to the governing bodies. And the COP, of course, can and should provide much guidance. And this is why COP decisions often take over a review of these bodies, like the review of the adaptation committee, the review of the WIM, etc. One specific constituted body that I wanted to stop for a minute because it has relevance for legal matters is the PIC, the Paris Agreement Implementation and Compliance Committee. So many times a treaty will have an enforcing body or a body that overlooks for the accountability of parties delivering of the obligations that they're committing. The Kyoto Protocol had a compliance committee which had two branches, one which was facilitative to assist parties in compliance, and one that was an enforcement branch. The Paris Agreement has the PIC, and the PIC is only facilitative in nature, so it's there to promote compliance with the provisions of the agreement, but it doesn't have enforcement powers. It is, of course, complemented by other accountability mechanisms like the Enhanced Transparency Framework and the Global Stocktake, which is a collective assessment that we do of the Paris Agreement. But as I said, is facilitative. As a constituted body, it has limited membership. It has 12 members who are elected by the CMA and based, of course, on equitable geographical representation. And the COP annually will receive a report from the PIC and will give guidance if it sees fit. But amongst the functions of the PIC facilitating compliance, they especially have to pay attention to parties' obligations to submit NDCs and all obligations related to the Enhanced Transparency Framework, the obligations to present certain information. And so if a party doesn't present their NDC or their BTRs, then the PIC can start what is called a consideration of issues and ask this party why are they're not complying with this obligation in order to facilitate their compliance. And so they do follow very closely this the compliance with these obligations, and we are expecting that for COP30 they're going to report, of course, on NDC submissions. As of April, they already sent over 170 letters because, as we know, the 2025 submission of the NDCs, which was due on February, was not delivered by many parties, and so they sent all of these letters. And so, yes, this is the place where we will find the information about submissions of NDCs, potentially an explanation from parties on why also they didn't submit theirs on time. The picture there is an explainer, and there's a link which we will put in the comments as well. But it's a link to an explainer on the PIC if you are interested in learning more about it. It's an explainer that here at Legal Response International we have developed. Moving on now to more practical legal aspects of this regime. We're going to talk briefly about the rules of procedure, so you are aware that they exist and where they are, why they are important. We're going to talk about the agenda setting. We're going to give an example of problems of process during COP29, and then just giving you a tool to find documents in the UNFCCC, because that's also challenging with the amount of documents and draft decisions and final decisions and reports. So yes, let's crack on with the rules of procedure. So as I was telling you before, one of the functions of the COP was or is to adopt rules of procedure as per Article 7 of the Framework Convention. They tried, but they haven't achieved this yet, specifically because there's this voting rule, which would help us to move away from consensus. But because of the rules of procedure need to be adopted by consensus, there is no consensus on the voting rule, and therefore we don't have rules of procedure. However, they do apply in draft form, except for the voting rule, which is Article 42, in case you're curious. And they cover issues like how to set the agenda, how to conduct the negotiations, what's the role of the presidency, where the sessions take place, and some other formal aspects. So they're still very much applied in every session, and they're very relevant, and there you can find a QR code for them. I'll only stop in the rules of procedure that relate to agenda setting, because we've all seen in recent negotiations that adopting the agenda is not necessarily easy, and there are all these questions about how can we add or potentially delete an agenda item, right? And so all of this is regulated in the rules of procedure. So when we talk about the agenda serves to structure the UNFCCC meeting and the negotiations in a session. So it's the different themes that need to be negotiated. There's first a provisional agenda that is circulated 6 weeks ahead of the session, at least 6 weeks ahead of the session. The provisional agenda for COP30 is already out there. And this one the agenda should be adopted in the opening plenary, but sometimes it's not adopted. There's the supplementary agenda, which includes any additional agenda item that a party is suggesting that was not communicated ahead of the distribution of the provisional agenda. And so in that case, we find a supplementary agenda. In any case, the agenda with all of these proposals should be adopted in the opening plenary, and there will be one agenda for each governing body. So there will be a COP, a CMA, and a CMP agenda. Also, the SPs, they have their own agenda according to their own functions and the norms of the treaty. So, of course, the GST, for example, the Global Stocktake, is an instrument of the Paris Agreement that is only under the CMA agenda, right? Whilst the Kyoto Compliance Committee is, of course, under the agenda of the Kyoto Protocol. However, there are many topics that are seen by 2 or 3 governing bodies, in which case we will have joint agenda items, and then we will normally have mirror decisions. Another type of agenda, of course, is the annotated agenda, and which is also circulated ahead of the session, and that includes a reference to the negotiation theme, the most relevant documents, but these are not part of the official agenda, but are very useful to prepare the negotiations. An example of why rules of procedure could matter is the recent adoption of the NCQG decision, the new collective quantified goal at COP29. And so during the process of negotiation of the NCQG, we saw many difficult moments. One of them being, for example, that because the negotiation room was not making progress perhaps rapidly enough, the president decided to have presidential consultations on an alternative draft, but he excluded LDCs and small island states from these presidential consultations. And so the next day, these parties came to the negotiation room and were presented with a draft text that was not discussed with them as it had been with other groups. And so at the point they even left the COP and the negotiations in this matter. Then the presidency presented a final draft to the plenary. It didn't see the negotiation room, so there was no transparency there. And what happened is that when the president was reading the name of this document to ask for if there were any objections, he did not look up to check that actually there were no objections. So after he gobbled through the decision, some parties, including India, they asked the floor. They said that they had asked the floor in advance, presumably to object this decision, but they were not given the right to speak. And so they challenged the process of adoption of the goal. And you can see what happened in this video. The link will also be provided in the comments, but at the 2 hour and 16 minutes, you can find the exact moment. So in this case, many questions remain like, was there a breach of the rules of procedure or not? And then the importance of the discretion that the presidency has to declare consensus. It was shown very vividly in this event, and so things as asking the right to speak or presenting a point of order adequately become more and more important when we're dealing with these delicate moments. If we want to make a formal objection, we need to ensure that we do it properly, so it's regarded and registered as such and not just as a statement, right? So I think this illustrates quite well why these things are important and have actual consequences. As I was saying before, this is just me sharing a guide to understand and find documents in the UNFCCC website, because it's very difficult to navigate, but at the same time is the official place where we find relevant information to the negotiations, the decisions, the adopted decisions, the official adopted decisions, final ones, but also the draft decisions during the sessions, the last draft, so you don't have to rely on sort of WhatsApp groups, and you always know that you're going to the right document, same as the agenda, etc. So do visit if you work in this space and you need to find documents. Do get familiarized with this website ahead of the sessions, and so you can find your documents easily and in a safe manner, so you know that you're in the right place. We'll spend now the last part of this session, this video, talking a little bit about text analysis and text drafting, and giving some examples of what to look at from a legal perspective, from the perspective of legal language as well, when we face text. So first, when it comes to text interpretation and legal terminology, we need to understand that there is a language, or that language matters when it comes to legal obligation. So the legal character of a provision, and then the actual impact that it has in terms of constituting a more or less binding obligation, for example, will depend on several factors, including the location of the text. The preamble, for example, as we say, has a more interpretative character compared to the operative part, where we find the actual commitments and obligations. The language that we use is also important. If it's stronger, if it's qualified, the precision that we put in the words, like, is this obligation well defined, or is it more like aspirational and wishy-washy? And the normative content as well, of course, the subject, if we are assigning this obligation to someone or not, or it's just, a general aspiration. It's not the same having a finance obligation for developed countries than encouraging all actors to mobilize climate finance. And we find examples of both in the treaties and in COP decisions. So, for example, here actually we see the wording "shall," which is the one of the verbs that it's used when we want to create an obligation. So the first example says support shall be provided to developing country parties for the implementation of the Paris Agreement here. So it creates the obligation to provide. It doesn't say who. It's not the same as perhaps other provisions where we say when the subject is present, developed countries, for example, as a subject of the obligation. Then here we have a subject in the second example, each party, so it applies to everyone, shall, but then it says as appropriate, which tones down the level of obligation, engage in adaptation planning processes. So we'll go a little bit more into what do we mean by qualifying language and the degree of commitment. So examples of words that are used to show different degrees of commitments are these. Consider means, when the COP decides to consider further in the line about a topic is just, thinking about not necessarily reaching a decision. May is an optional requirement, and so the party would have discretion to comply with it or not. Should is something that is advised to the parties, but it's not compulsory. Shall, which is the one that we just saw, is a compulsory requirement. Also, must is compulsory. And then when the shall, as before, shall as appropriate, or here shall as endeavor, when it's accompanied with one of these words, it's weak compared to just the shall, so it's weaker. So do bear that in mind, because sometimes we could get really excited because a provision or a COP decision says shall, but if it says shall endeavor, it means they just have to try, right? So it's not the same as an obligation, a compulsory requirement. And so here we have Article 9, which is a really good example because it has 3 different verbs in the same provision. So developed country parties shall provide financial resources to developing countries. We have the subject defined, the beneficiary defined, and a clear obligation to provide finance. But then we have other parties, just non-developed country parties, who are encouraged to provide. They don't have an obligation. This is a voluntary commitment or call for them to provide support. And it says so here, voluntarily. And then finally, developed country parties should continue to take the lead in mobilizing climate finance, which is like a weaker status from shall. Is something that they have to work towards, but not necessarily to deliver, right? We have then the cases of qualifying language, as I was saying. So when one of these verbs is accompanied by as if appropriate or as if necessary, as if applicable, means that the subject will have the discretion to define if the obligation is applicable to them or not. Shall endeavor, shall strive to, of course, it weakens the obligation because it only means, as I was saying, that you have to try to reach that obligation. And then another example is when a COP decision, for example, is urging parties in a position to do so, to do this and that. In this case, the subject is also qualified. So parties who, again, think that they are in a position to do so are the ones that are called to respond to this to this mandate or to this request. Then we have other legal wording that definitely leads to nothing. That's why we say like future aspirational or no future. So when we hear that, the COP or parties should take steps towards devising a process that is just, something aspirational for the future, or where we find references to where sufficient information is available, that means that the obligation is conditional to a circumstance that is not yet there. So it's a conditional obligation. And then with a view to, many times in COP decisions, we find this reference that parties, should reconvene to discuss this topic 2 years from now with a view to blah, blah, blah. It just means to resume the conversation in the future, but with no obligation to reach to any decision in particular. Finally, there are certain mechanics when we draft text, when we're negotiating text. For example, the use of square brackets in a draft text means that wording is not yet agreed, still under negotiations, and so we can see them in a sentence, or we can even see them at the beginning and the end of the text, because it means that nothing is agreed until everything is agreed. When people say that we're using or integrating agreed language, means that it's a language or a wording that was already used in a COP decision or in a climate treaty. And so many times parties resort to this precedent as a way to ensure that the point that they want to make is not blocked for being foreign to this regime. Then we have the concept of constructive ambiguity, which is very useful, but it also has some risks. So constructive ambiguity means reaching to a concept, reaching out to a concept that maybe we don't know exactly what it means, as a way to avoid parties from blocking any other idea. So in the GST, there was this idea of having a call to phase out or phase down from fossil fuels. And those, we know what those words mean already because we've used them before, but some parties were not okay with any of these references. And so as a solution, they came up with this transitioning away from fossil fuels. Similarly, in the negotiations of loss and damage, this was a concept that was elaborated to move away from the concept of compensation and reparation, because this created a lot of objections, especially from developed country parties. And so these sort of concepts, which meaning is not clear when they are agreed or when they are used first, are very useful to reach these agreements, to include these references, but then they have the challenge that they need to be further explained or defined by COP decisions, and that's not necessarily easy. Finally, I just wanted to share some resources with you. Very, very important for all of these legal text and language is the Guide to Climate Negotiations Terminology that you see here in the right, which was developed by IID and LRI. And here are some others that might be of interest, like our explainers or the IID to becoming a UNFCCC delegate, etc. So I hope you find them useful, along with our Paris Agreement A to Z, which is an app available in the App Store of your Android, of your iPhone, where you can find the provisions of the Paris Agreement and the relevant decisions to each provision. We update the content of the app every year. And so it's good to have it handy for your negotiation, so you can always go back to the norm in your negotiations. I hope this session was useful and that you can take some of what's been discussed here to further enhance your toolkit as negotiators or as observers supporting the negotiations, and you can understand a bit better what's happening in terms of law and governance in this regime. Thank you for this, for your time, for your attention, and good luck with your participation in the negotiations.